The type of lawyer that you need to find for a collection matter depends a little bit on your situation in the collection matter. If you're a creditor, then you would probably want to find a collections attorney or a creditor's rights attorney who can help you enforce your judgment or collect on your debt. If you're a debtor or you're an alleged debtor where someone has accused you of owing a debt, you would likely want to seek out either a consumer rights attorney who can help let you know if any of your rights have been violated by the collector, or a bankruptcy attorney if you'd like to look at discharge of debts more broadly. If someone owes you money and you think that you need court intervention to collect, your options are generally going to come into two categories. One is conciliation court, which is also called small claims court. And in conciliation court, you can represent yourself, even if you're a business, and you can bring a claim for recovering up to $15,000. In conciliation court, both sides get to tell their side of the story directly to a referee who then makes a decision. If you're asking for more than $15,000 or your matter is more complex, you can have your matter heard in district court. In district court, there's no limit on the amount that you can recover. Businesses must be represented by an attorney. And once you get a judgment, it's final upon entry. Well, a judgment is a court order for the debtor to pay, but the court doesn't generally take it upon itself to enforce that order. So instead, it provides tools for you to use, usually in conjunction with the sheriff or an attorney. And those tools can help you discover assets that the debtor has that can be used to pay your judgment, and they can also help you collect those assets through garnishments or levies or things like that to help you actually collect and pay the judgment off. The first thing that businesses should do to make sure they get paid is to use contracts with their customers that clearly lay out the terms of the transaction. From there, they should make sure that they follow up by billing promptly after the work is completed, and if they're not getting paid, they should follow up by having a system in place for reaching out with reminders and overdue notices. Just acting promptly often is enough to help a business get paid more often. Ordinarily, parties are responsible for their own attorney's fees unless there's either a statute that allows you to recover for your specific type of claim, like a mechanic's lien, or if you have a contract that allows you to recover mechanic's liens. Otherwise, generally, you're responsible for your own fees. No, changes of ownership in a business, unless the business is publicly traded, are usually private transactions. The only exceptions would be if you needed to update some of the registration information with the state, such as your registered address or agent. You'd also need to perhaps notify the IRS if the tax matters partner or someone else who's directly tied to the business's tax filing is changing with the ownership shift. Yes, companies like LLCs should still have insurance to protect against liabilities. Those insurance policies can not only help you avoid defense costs by covering them for you, they can help you resolve matters earlier and protect against a wide range of liabilities. The LLC shield itself is not absolute, and it should be relied on as a last resort in case liability ultimately does get through to the entity. If a person owns a business by themselves, even if they're married, it's still their business alone. Their spouse may have an interest for purposes of family law and other things if there's an asset distribution, but for collection and business purposes, the sole proprietor of the business is the only owner. Minnesota does allow for wage garnishment to satisfy a judgment, but for only a portion of the wages. Minnesota allows collection of 25% of wages above $290 a week, and that number can change as the minimum wage changes.